Good morning, good afternoon, good evening, everybody. Thank you so much for joining us today on another session of We Connect Academy Learning from Women Leaders Around the World series. My name is Andrea, and today I am really happy to introduce Kiran Seiter. She is the managing partner of Seiter IP Consultants LLP, a women owned certified IP boutique firm based in Singapore. I think this is the first time we have a presenter from Singapore, so that makes us very, very happy. Sater IP Consultants provides trademark and IP services throughout Southeast Asia. She has over 10 years in managing trademark and design portfolios in all Asia Pacific jurisdictions. She has experience working with small companies, startups, entrepreneurs, and large multinational corporations. We all know that intellectual property is a valuable intangible asset. It can generate revenue for business, so it should not be sidelined but prioritized. This webinar will cover the basics of intellectual property for SMEs, what you should know as a business owner, and how you can protect your rights. I'll let Kiran introduce herself, but I would like to remind all the attendees that you are in listen-only mode. So if you have questions or any comments, please write them down in the Q&A box that you will see on the control panel at the right hand of your screen. We will make sure to read them out loud once the webinar is completed. Please make as many questions as possible. This is a one chance opportunity to learn as much as possible. We also want to remind everybody that the recording of this webinar will be available after today's session, and it will be emailed to you tomorrow on a reminder email, and follow-up email. So it will also be available on our YouTube channel. So thank you so much, Kiran, for being here with us today. Over to you.
Hi, thanks, Andrea. Good morning, everyone. Good afternoon and good evening, depending on where you're from. I really appreciate you coming online today to listen to me. And I do hope that after the session, you understand IP and trademarks better, and it will help your business in more ways than one. My goal to hold this webinar was mainly so that I can impart my knowledge on this area of law, and I think it's very crucial because I find a lot of businesses, particularly smaller businesses, tend to focus a lot on sales and marketing, which I understand, but there are also circumstances where because they do that and they don't prioritize the IP, someone comes along, takes their idea or takes their right, and then sometimes it's very difficult to defend or get it back. So main concerns are always cost. So I'm going to talk a little bit about that as well. So Andrea was very kind to give you a background on myself, and I've been doing IP for more than 10 years. Actually, I would say more than 12, 13 years. It's ingrained in me. It's a part of me, and I do handle matters not just in Singapore, in Asia, and also in the US through my US office. So I just, before I start the session in detail, I just, if it's possible to, on a scale of 1 to 10, 1 being not very familiar, 10 being familiar, just to give me an indication how familiar each of you are. We don't have to have everyone put in the number, just as many of you, if you can just type in 1 or 10, depending on your range. So that gives me an idea of how familiar some of you are, so I won't go into extreme detail, or I will go into as much detail as I need. So if you could do that in the Q&A box, that'll be great. And then I will start the session in detail.
So far, we have 6 answers, 7 answers. We have
Okay.
2 1s, 2
Okay.
5s, 2 6, 1 3.
Okay.
So really,
So it's a mixed range. Okay, that's good.
yeah, a broad,
That's good. So
yeah,
all
level
right.
of knowledge. 1 4, another 1, another 5.
Okay, great. Okay, so it's a good mix. That's good. All right, I'm going to move on to my first slide. So introduction, IP is an invaluable intangible asset. Unlike your house, where it's actually a tangible asset. So we usually regard IP as intangible, and because it's an asset, it actually can generate income for your business in a number of ways. For example, royalties through licensing arrangements, franchising, distributorships in overseas markets, or even after a while, if you're not using a particular, for example, you have a patent that you're no longer interested in, or a trademark you're no longer using, you can actually sell that, and it could be of value enough that you can actually make a decent amount of income from that. Usually there'll be a valuation process, but this is something you can explore. So I'm sure some people do things by domain names. Those are also IP, and those are also valuable. People pay money to buy domain names if they lose out on a particular one that they're really interested in. So these are different ways in which you can actually generate income. And as I've said already, because IP is often sidelined over marketing or sales, mainly because costs tend to be a big hindrance. And it can get expensive because IP rights are territorial. But I've also seen that if you have a good IP strategy and a strong budget, and I'm not saying like, have $100,000 set aside for IP, but if within your organization from the outset at the beginning of the year, you set aside a specific amount of money within your budget for IP, that actually can help a lot, and it can benefit your business in the long run. So IP should always be an important part of your business. It should always be in discussion at the forefront, as important as marketing and sales, because it can generate revenue for you. So this is something that I feel a lot of businesses do not clearly understand. Some do, because they may have been affected by someone else taking their brand or their patent or copyright, and therefore they begin to prioritize it. But the companies that I've worked with a lot of times tend to come to me when it's a little bit too late. So intellectual property, what is that? It is basically protecting your assets. Um, for example, what kinds of assets are we talking about? So we have the works that you produce, like photographs or videos, the shape, configuration of a product. So you have iPhone now. Prior to the iPhone, we had like flip phones. So the iPhone, when it first came out, the shape of the iPhone was kind of unique. So that was actually protected as a design. So it protects how something looks as opposed to how it functions. Like the trunky suitcase, there's a suitcase where you've seen children with their own suitcases at the airport, very fancy, that was actually protected as a design. And then your innovation. So you have things like the electric toothbrush is something that I like to talk about, because we all used the conventional toothbrush, I mean, for years, I'm sure. And then somebody came up with the idea of an electric toothbrush with a rotating head, which cleans better and with other functions. And that, obviously, when that person developed that idea, they must have, they would have registered as a patent. And now we have so many of these going around, different types doing the same thing. And then, of course, your brand and your identity. So I look at trademarks and brands as as identities, just as we have our own identity. Our names are our identity. The trademark or your brand is the identity for your business. So you don't want somebody stealing your identity and trying to make their business as if it's yours, and just, write off the goodwill and all the customers that you've built over the years. So you need to, and similarly, you don't want to touch on anyone's toes in doing the same thing by registering something that's already similar to what's out there. So, big brands like Coca-Cola, Dior, a lot of fancy brands, their brand value is very high. So there are different types of IP. Obviously, in one company, depending on your business, you could have different types of IP within your organization. So you must be able to determine what it is that you have in order for you to want to protect that. So, for example, the iPhone is used as a good example. It has all the at least three of the IPs. You have the brand, which is the Apple brand. You have the design, which is the shape of the phone, and then you have the function, which is how the smartphone actually functions. So there are three types of IP in just the one item. So that's something that you and if you don't have the budget to protect everything, then you have to determine within your company which is it that I need to prioritize first. So that's where the strategy comes in. And you can try to, hopefully with this session you will learn a little bit about how to do that. And if you are not sure how to go about building the strategy, then you can actually consult someone and get someone to guide you in the process. That I think would be also one of the ways you can go about doing that. Okay, moving on. Um, so a big question that I get from small businesses or startups, they always say, but why should I protect my IP? What's the big deal? I mean, I don't need to protect my trademark. It's okay. I don't care if someone takes it or uses it. Well, maybe in the initial stages you don't care, but if your brand develops enough goodwill or enough um, you've enough customers or your customers rely on the brand value or rely on the quality of the products that you are offering, then if someone comes along and takes that, it could not necessarily be in the country you're in, it could be someone in China, which a lot of brand owners are facing problems. Then you're gonna tell yourself, oh, I wish I had done something sooner, because customer loyalty stems on the value that you're giving them from the product and the services. So if someone comes along and you gives a product or services that seems to be similar to yours but is of lower quality, then that's not going to be good. For example, I give you an example: the Crocs shoes. When they first came about, the Crocs was actually, there are a lot of counterfeit, fake Crocs out there, not the genuine product. So, and that is a form of footwear. And if you, I think, go on, say, I've heard of an incident where a child, I think, was wearing one of these fake Croc shoes, and I think a foot got caught in an escalator. And because it was a fake Croc shoes, it didn't protect his foot, or there was some injury to the foot. So if others who have seen the incident and saw that that child was wearing Crocs, which looked like Crocs but not really the genuine product, that tarnishes the image of the product and the brand. So that was something, that is why Crocs, for example, they really heavily invested in making sure they stamp out all these counterfeit products and all these fake goods, because it affects the value of their brand and their goodwill, and how customers look at their product if you find that the product isn't really doing what it's supposed to do. So that is one of the reasons why you should protect your IP, because you don't know how a third party can damage your goodwill or damage your the image that you've built for your business. So and of course, I've put here primarily, it is definitely essential if you want to grow your business, make money, and establish a presence in a market that you're in. It could be one country or many countries. So overlooking your IP could hurt your business, and sometimes it is too late. For example, I've had cases when engaging with distributors in overseas markets, the brand owner does not file their or protect their IP in that country ahead of time, whereas they engage in a distributorship agreement or a licensing arrangement, and the party within that country feels like if they don't have the trademark or they don't have the protection, that's going to hurt their business. So they go ahead and file first. And what happens then is the brand owner, when he or she or it is ready to file in that country, it will be blocked by this earlier filing or earlier right. And therefore, the distributor would then have the upper hand over you. So I've had a client face this problem with a lot of inventory stuck in the country, and they couldn't do anything because their distributor, whom they have severed the agreement with filed for their trademark in spite, and that caused a lot of problem for my client, and they had to actually find a way to get it back, which led to them spending quite a lot of money to buy it back from that party. So these are circumstances, these are real life circumstances that happen. And so for this reason, I use the word stolen, because that happens a lot. And this is something you want to make sure it does not happen if you are planning to expand overseas and have marketing, having sales in other countries through distributorships. Because you, unless you can open a branch everywhere, or or store every country, you're gonna probably rely on distributors. So you have to make sure before you do that, you get your mark protected or your IP protected in that country. Otherwise, you could risk losing it to your distributor. I mean, we trust people we work with, but things get soured. You don't know how things are going to take a turn in the future. So for that reason, it is very important. Just be cautious. Always have your agreements in place. Don't assume that everyone's going to be trustworthy, whether it's friends, family, or people you working with out of the blue. So this is something I can't stress enough. Make sure that you protect your IP before you go into the particular market. Um, so your contract must discuss confidentiality and specify who owns the IP at the outset. So a lot of times these days, a lot of us are developing apps, developing different types of software. We don't know how to do it. We engage a third party to develop the software or the program. So at the in your contract, you must make sure you specify confidentiality. You must make sure you have the rights to that software or that program assigned to you through a transfer agreement, so that you are the rightful owner of that product or that software. And if it's an employment situation, then yes, I mean, I'm assuming in your contract with your employees, you would have a clause on IP which says that anything you develop for the company will be owned by the company. So when you're involved with third parties, make sure your contract covers these issues: confidentiality, ownership of the IP, very, very crucial. Otherwise, when your product does well and you're getting more customers, a third party or that party will come in and say, hey, wait a minute, I own rights to this as well, or this is actually my IP. You're the one who stole it. So you don't want circumstances like that. So everything has to be clear. I know a lot of us are like, oh, I can just find the contract online and do it myself. Yes, that's possible, but I don't recommend it, because it must be tailored to your business. A lot of things online are general, or it relates to something else, so you have to make sure that you get it specific to your business. And that, if you have an existing template or contract to work off, that saves money. Then again, if you have to rewrite the whole contract, that does not save money. So very, very important. We want to save money to do a lot of things on our own, but there's so many things or issues go into it that it is best to actually get some legal guidance on this issue. You just have to find a firm or a lawyer that is willing to do this with you. If you're a small business and you can't afford to pay the hourly rates, there are more and more firms who are charging fixed rates, so you can definitely do that. Um, okay. So in many cases, IP is an important part of a business profitability, and in dynamic, fast-moving industries, it can be the difference between success and failure. IP protection is territorial. What I mean about that is if you protect your IP, your patent, or your trademark, or your copyright in one country, it does not mean you're protected all over the world. If you file something in the US, it protects you only in the US. If you register something in China, it protects you only in China. It does not protect you even in Hong Kong, although it's part of China. So it can get costly if you're planning to market your products in a few different countries. So I would say, for that reason, the strategy and the budgeting is very crucial, but IP protection is territorial. You have to realize that if you protect it in one country, it does not mean you're protected globally. And then I've got questions about the using of the R symbol. Well, the R symbol signifies registered. So if it's registered in the US, you can put the R symbol. If it's not registered elsewhere and you want to start selling overseas, then you just don't put the R symbol. You can state in the product packaging that such so and so is a registered trademark of so and so's country, in so and so's company in whichever country. Like Coca-Cola does that at the bottom of their labels. You can do something like that. Or you can put TM. TM basically means that is a trademark of the company. It it means it's not registered yet, but it is a trademark. It's something that you're using as a brand. So that is another option that you can have until you receive registration, and then you can put R. So if you register in all the countries you've applied for, then you can use the R, not a problem. But ultimately, it does not mean with or without the R you are going to be at a loss. No, as long as you have your registration certificate, you can prove you're the one who owns this particular trademark or the IP or patent, then you are the one with the rights. So the R is just to notify, or the TM is just for notification purposes to tell third parties, hey, this is a trademark of mine. So, it's not just use of a word in general. So that's the difference. So if you have plans to expand overseas, you must strategize and plan well. So what I'm saying is you have to think of the economic value of your IP, what it can generate for you down the line. It doesn't mean that it will immediately start generating revenue for you, but if you have a licensing deal that could generate money for you quite quickly. And then you have to think why you're doing this. Why am I protecting my IP? Is it because I want to make sure that I don't get sued by someone if I'm going into, say, Malaysia? I don't know if anybody in Malaysia has this brand already. I just want to make sure that I go in first and not get sued before I start selling. Or is it for offensive reasons? When I say offensive, I mean you want to attack, you want to make sure if someone infringes your brand, you have the rights to be able to go after them legally in the law, in the eyes of the law. So that's more of an attacking mode to protect your brand, to stop someone from stealing it. So it's defensive, offensive. It could be both. So when you're thinking of IP, you have to ask yourself why. Why am I doing this? What's my goal? What is my intention? What do I want to get out of it? So if you could do that, that will give you the stepping stone in developing your strategy. So the types of IP that are quite common would be copyright, design, which is basically the shape and configuration of a product, patents, which I've explained protects innovation, and then trademarks, which is your identity. So I'm going to touch on the first one, which would be copyright. So in my mind, copyright protects the expression. It's whatever you put down in paper or tangible form. So copyright protects the expression of ideas. For example, literary, dramatic, musical, and artistic works. Now, what is that? What are literary, dramatic, or musical, artistic works? Well, things such as like photographs, videos that people post on YouTube, or novels that you write, computer programs, music, paintings. Now, these are all copyrights, works that can be protected by copyright. And the author of the copyright has the right to produce, reproduce, publish, perform, communicate, adapt his work. If you don't have consent, then that means there's a potential infringement. And in the infringement, whether or not the case is strong or weak depends on the extent of copying. So if someone writes to you and say, hey, you've copied or you've taken using my photograph and you've not paid me any royalties, I've had that situation a couple of times recently. Well, then you have to address it as it comes, and then deal with the country that is in question and try to get legal help to make sure that you didn't do anything wrong. There are, of course, exceptions to infringements. In some countries, copyright is protected automatically. For example, in Singapore, you don't have to register any copyright ownership. The owner gets automatic protection, but you have to be able to prove that you're the one who first produced the product or the particular subject matter, the works. And in other countries, such as the US, copyright must be registered. So Depending on which country you're interested in, it could be something you need to specifically look into registration, or it could be just an automatic, right? It's good to check beforehand. In terms of how long a copyright, is valid for, it depends on the nature of the copyright, and it depends on the country. So different countries will have different terms of protection. So if you're going into a particular country, it is best to get as much information as you can from a IP counsel or IP lawyer, so that you know what you're going into beforehand, including how much it's going to cost if you actually need to register. Um, Now, what is not protected? This is something that I get a lot of questions on. Most of the time from these small businesses in Singapore, they're always talking about an idea that they have, and they don't want someone to copy that idea or a concept that they are developing. So these are some of the works that are not considered protectable. So in Singapore, I give an example of, these online deliveries, supermarket online deliveries. Now, there are a number of companies who do this online deliveries. They're just different supermarkets that offer this service. So that idea of being able to buy online and send it to your home is not an idea that you can actually protect. But what you can do is have a brand that sets yourself apart from your competitor. I mean, similarly, in the legal field, we have many law firms who do different types of area of law. I have many IP firms out there who do the same thing as me. So the idea is not something that is something you can protect in that sense, but you can stand your put your brand out there and make it different in terms of the quality of your products, your service, must be excellent. And then from there, you develop, that is how you're going to get your customers. So a lot of times they ask me, I have this idea, can I actually protect this in any way? And I'm like, sometimes it's not the idea itself. If you put it down on paper, or you conceptualize it and you make it into something, turn it into, I mean, like an actual product, tangible itself, although it's an intangible asset, but then you can protect it. Otherwise, if it's just talk, and something you think about, then it's not something you can just protect under copyright. So the other things like discoveries, procedures, methods, this is not protectable under copyright. So so this is something, if you're wondering whether you have an idea, is this something I can protect, you can ask, you can find out. There's nothing wrong with doing that. And then you can take the next steps. If there's something you have to put down and make it into a tangible form to be able to be registered, then you can do that. I give you an example. So for example, a speech or a dance that has not been written or recorded. Now that is something that you can't protect unless and until it's written or it's recorded. So that is what I mean by, putting it down and expressing it and having it in tangible form. Okay, so that's a nutshell of copyright. I'm going to move on to designs. Okay, so what does the design, what exactly the designs protect? As I say, they protect the aesthetics, how something looks. So a design refers to the features of shape, configuration, colors, pattern, ornament applied to an article or non-physical product that gives that article or non-physical product its appearance. Design can be two-dimensional and or three-dimensional and can be applied to everyday items. Example, jewelry, design, swatch, Crocs, the Coca-Cola bottle. So these companies, the companies who own jewelry, they actually do register the design of specific types of shapes of the jewelry. It could be earrings, could be a ring, could be a pendant, could be anything. If they feel that design is unique. Crocs that I've talked about, they also have designs that they file, that basically how the shoe or the footwear looks. And then of course Coca-Cola bottle, they feel that their bottle is very uniquely shaped. So they try to protect it, or they protect it under design. But one very crucial, design and patents have very important requirements in order for you to get them protected or registered. The design must be new, so it should not be disclosed to members of the public prior to filing it. Otherwise, you lose what we call novelty, and then you're gonna not be able to register it. Most in Singapore, you don't have a examination, it's just formalities. So you will get your registration quite quickly. And that is so for a lot of countries, not the US though. That it's more, they're more complicated in protecting designs. But if a third party finds that your design was not new when you registered it or when you filed it, they can attack that particular design registration and try to revoke it. So you can get your IP protection, but if you did it in a way where it wasn't really protectable to begin with, you can get cancelled, you can get revoked. So it's not like once you get it, there's no way it can be challenged. It can be challenged by a third party if they feel very strongly about it. So be careful not to disclose the design to anyone until a design application is filed. And here I've put some pictures of some interesting looking designs that people have filed or registered for. It's just everyday product. One's a chair, or one's a seat, and one's a kettle. And then of course, the very famous, the Dyson vacuum cleaner. So they have filed to protect their design because it doesn't look like the typical vacuum cleaner we've seen over the years. So clearly they wanted to protect that. Okay, I'm going to move on to patents. Um, so patents are very popular. That's one of the most popular type of IP that people want to protect because they know it generates a lot of value, a lot of money if it's done right. So patents protects innovation. It's the most sought after IP because of the revenue potential is huge. It is the most expensive to protect, stringent requirements and examinations, and takes 5 years to register sometimes. It depends of whether it's a straightforward case or it is quite complicated. So a lot of times people are like, well, why do I bother if it's going to take me 5 years? Because at the end of the process, when you get your registration, it actually, that's so valuable that you can do so much with that registration, which is why, you must have seen Apple and Samsung always going at it with each other because they know how valuable these different patents are. So they're spending a lot of money on trying to defend their patents. So I would, of course, always advocate to protect as opposed to not do it. There are some types of innovation that people rather keep as trade secrets. You could do that. You could discuss and come up with a plan whether you want to actually, because patents only last 20 years. So after 20 years, anyone can use the patent. Anyone can just, follow whatever, claim specification and develop a similar products. You can't do anything after 20 years. Whereas if you feel you want to protect your patent for longer than 20 years, you don't want it publicly disclosed, you want to keep it to yourself, then you might want to reconsider whether you want to file the patent. It all depends on, are you planning to do a licensing deal? What are you planning to do with that patent? Is it more just for your business, or are you actually intending to license it out and generate revenue for yourself and your business? So that is where you can distinguish whether you want to file or not to file. Because if it's more fair, then the question is, what happens if somebody uses something similar? That's where your strategy comes in. You need to talk to your lawyer, okay, and hash out all the worst case scenarios. What if I don't do this and then this happens, and what happens then? And what if I don't want it to be publicized in 20 years because it's a very, like, you know it's very valuable to me. I don't want someone to just start engineering and producing this massively in China because it's going to be affect my business. So these are questions you need to talk with your consultant or talk with your lawyer to get an idea of what you should and should not do. So patent is a monopoly right given to the owner to enable him to prevent others from using, copying, making the invention without his consent in the country in which he has obtained patent protection. So consent is very, very important when it comes to IP to determine whether it's infringement or not. A patentable invention can be a product or process that gives a new technical solution to a problem. It can be a new method of doing things, the composition of a new product, or a technical improvement on how certain objects work. So it is basically protecting technology and functionality of a product. So examples would be a smartphone. How we used to use the phone very differently from how it is now. The smartphone allows you to do so much more than just making phone calls. So there's technology that goes into how that works. So the owner of that technology protected the patent. So it could be not just Apple, it could be different elements that are in that particular product that are owned by different. So for example, I've had a client come to me where he developed a particular type of chip. Okay. And that chip was something that was necessary by another company needed that technology to make their product work. So what they did was they approached the owner of this particular patent with who owns the chip to ask if he could license that so that they can use it. So, electronic toothbrush, as I've said, or Bluetooth technology. Now, if you are making a product that requires Bluetooth technology, now you got to go to the owner of the patent of the Bluetooth to ask for consent or for licensing arrangement to use the Bluetooth in your product. So this is where one product can have different types of IP composed into one, and some based on license, and some which is owner right. So it all depends on the type of product you're using or the type of product that you're developing. So, and then of course the light bulb. That was a very good innovation for all of us, right? So that is pretty much what patents is about. I've actually just simplified it for you because of time, but just for if you have any questions, you can always ask. Okay, requirements again, like design. It must be new. It must not have been made known to the public in any way around the world. Of course, there are in some countries grace periods where they allow you to still file even though you have some form of disclosure. Um, you must have an inventive step. These are requirements before you file, so you need to have these before you even consider filing for a patent. The invention must be something that represents an improvement over an existing product or process that's already available. Example, the electric toothbrush. So you have different types of electric toothbrush out there anyway. I'm sure the different owners of these different brushes are trying to protect different aspects of the patent. So if you have a product that you're improving on, you can just file the patent for that aspect of the improvement that you are actually interested in protecting. For example, okay, another example that I forgot to write, the bicycle. These days you have foldable bicycles. Who would have thought that bicycles could be folded? Now, whoever developed that um, section of the part of the bicycle that you can actually fold, that aspect of it is protected by patent. So the bicycle in general is not, but the fact that the way in which that the bicycle can be folded, that can be protected. And then industrial application, the invention must be useful and have some form of practical application. So if these are too technical, of course you can always again have a discussion with your IP lawyer or anyone who's in the IP field, and then you can get more clarity on these requirements beforehand. Okay, so trademarks. I'm going to move on to trademarks. Well, it's a sign that's used in your business to trade, to distinguish goods and services of one trader from others. It can be a letter, a word, a number, aspect of packaging, color, shape. Now these are more difficult to protect, colors and shape. Like the Tiffany box, they've been trying to protect the color, the green, for a long time. I don't think they're very successful. Even Cadbury tried to protect the purple for chocolate. It's not very, they're not very successful. You would think that they would be, but no, because color should be allowed to be used by anyone. So trademarks, when you protect it, it gives you an exclusive right to that particular trademark. So it pretty much means you're going to block out anyone else from using it. So by obtaining a registration, the trademark owner has exclusive rights to control the use of the trademark, and includes the right to restrict others from using the registered trademark without consent, And it also prevents a later trademark, which is similar or identical to that registered trademark, from being registered in a particular country in relation to the same or similar goods or services. So it has to be something that is obviously similar. For example, I would say if you have a product that you are selling, which is for coffee or tea, and someone registers something similar, for example, paints, the question is it something you should go after them for, because you're dealing with coffee, tea is nothing to do with paints, so then does it affect your business in any way? If not, let it go, move on. If it does affect your business because they're a big company and they're probably going to go into coffee and tea, then you can go and say, hey, or it's damaging your goodwill in some way, then yes, you can try to stop them. But then again, it depends on how successful you can be. So that's a matter of assessing the case beforehand. Um, so applying for a trademark, before you begin, you have to have the following in mind. What is the trademark you want to protect? What are the classes of goods or services? What are the countries you want to go into? So these are the three things I always ask whenever someone's asking me for a fee quotation. I have to know these three things in order for me to give a fee quote. Class of goods or services, basically just categories of goods and services. I'll explain a little bit more in my next slide. And then secondly, you got to ask yourself, do you want to do a trademark search beforehand? This is before you file, to know your risks and save money. Because if you file something without searching and there are problems during examination, you are going to have to spend money to overcome those objections. So a trademark search is recommended, not compulsory. You can always get a fee estimate beforehand to decide whether you have the budget for it or not. I would recommend it, but it all depends on budget again. And then get an idea of the costs involved before proceeding. So goods and what is classification of goods and services? We, as IP lawyers, we use the NICE International Classification. You can Google that. It will give you a list of all the categories. It's not that complicated, but in each category, there are multiple types of goods and services. So before you go and protect your brand, you need to understand what classes your goods and services fall under. So there are 34 classes for goods and 11 classes for services. So some of the popular ones: Class 3 for cosmetics, perfumes, 5 for pharmaceuticals. 9 is quite popular because it deals with software, hardware, computer related products. Clothing is class 25. So you might be asking, so how am I going to know what's mine? So you can of course check the NIST classification, just do a Google search. If you're not sure, can ask an IP lawyer to help you out. Or there are online platforms where you can do a search of your product and it will reveal the class that's relevant to it. It's not very complicated. I'm happy to share more about this if anybody's interested. It's not very difficult. I don't mind going through it. It's available online, so it's not something that is difficult to access or find out more on. Um, so as trademarks are territorial, they have to be filed separately in different countries. Um, and the time frame for the trademark to register varies country to country. In some countries, it can be as fast as 6 to 10 months, and others, it can be as slow as 3 to 5 years. So I've had, like, in countries like Bangladesh, where it takes almost 7 years to register, and then the renewal is 10 years. So it depends on the country. There are some countries have a lot of backlog, like China used to have a lot of backlog, India, a lot of backlog. In Singapore, it's pretty fast if there are no problems. So there's 4 stages of a trademark application. You have the filing stage. So each stage, you have some cost aspect to it. You have filing, so the initial filing that you do, and then your application goes into examination. And then you have, if it passes examination and there are no objections by an examiner at the registry, then your mark gets accepted and published. At that stage, a third party can come in and block you if they feel it's similar, or it will go through smoothly to registration. So these are typically the different stages, and each stage can go smoothly. It can become complicated. It really depends on the brand and what you do and what you're selling. So every step of the way, just you have to be able to be counseled or guided on your application. What's going on? How do I overcome this? Is this a big problem? So you need to have a good IP counsel or guidance on these different aspects of the trademark application. So reasons to file overseas, there are many countries with a first to file policy, which means that the first party to file the application will have prior rights over others, regardless of who uses the mark first. So in the US, they recognize first prior use, but in a lot of countries, they go based on first to file. So you can be using for 20 years, but if someone comes in and files the brand or trademark first, then you are going to lose out because they will be deemed to have prior rights over you. So it is very important to know which are these first to file countries and which are first to use countries when you're dealing with your IP. If you delay, again, you risk someone else having to file the same or similar trademark before you. And if you lose your prior rights, it could cost more money to get your trademark back than had you filed the trademark in that country in the first place. As I mentioned about one of my clients who had inventory stuck in their warehouse and their distributor filed their trademark before them. So they had to pay a lot of money to buy it back. So in terms of strategy, just very quickly, you ask these questions when you're trying to develop it. What does this mean? Why do I use who, what, where, when, why, how? This is a good platform, a good foundation for each of you to have when you're trying to develop your strategy. So you ask yourself within your company, who is going to own the IP? When you're actually, if you're, say, for example, using third party to develop something for you, or do you want to own it by yourself or your company? What is the IP that you own, and what do you intend to protect? When do you want to protect it? Do you want to do it now? Do you have the money? Do you want to do it in 6 months, in 12 months? Have a plan as to when you want to do that. Which countries, where do you want to file or protect your brand or your IP? Just in one country where you primarily do your business, or in 5 countries? And if it's in 5 countries, then you have to ask yourself, okay, do I do that all 5 now, or do I do it in stages? You might have to do in stages to save money, because it'll be very expensive otherwise. Why? As I mentioned, do you want to do it for defensive reasons, offensive reasons, or to generate revenue? Finally, how, excuse me, do you want to file the patents or the IP or trademark nationally or through the international route? So there are 2 different ways in which you can protect or file. Could be national, could be international. This again depends on the countries you're going into and the budget that you have. Sometimes the international route is cheaper, and otherwise, if you have just one country, then I would say go nationally. So it really depends on how many countries and whether it's a member of one of these international treaties. So this is very, very useful when I talk to a lot of my clients, because it really just makes them focus on how to develop their strategy. And so stemming from that, have a 6 months, 12-month plan, work within an annual budget, and depending on the business that you have, prioritize based on the type of IP, your country, and the classes if it's trademarks. So that way you can actually use your budget wisely, because you identify the IP that's most important to you, the country that's most important to you, and the classes that are most important to you. It doesn't mean you can't do the rest, but you can do it in stages. So finally, costs. Because it's territorial, it can get expensive. Patents can cost anywhere between $10,000 to $30,000 per patent, depending on the country. Trademarks can be costly too, depending on the classes. So the fees are based on each class. So if you have 10 classes in 5 countries, it's going to cost a lot. So one class trademark can typically be about $1,200. So it does add up. And if it's just one class, if you have 5 classes, it's going to be a lot more money. So this not meant to scare you. It's just meant to let you know that things can get expensive. So you must have a strategy. You must always tell yourself, what do I do first? Which one can I do later? And then follow through and have um, the internal strategy, and also have someone to guide you. That's the best way. That's what I would do. And I feel that if you have a good guide or a good attorney, then you'll be okay. So I think that was it. I think I have 10 minutes for anybody who has any questions. Please feel free to ask. I'll be happy to answer them.
Yes, thank you so much, Kiran. That was very informative and really easy to understand. So thank you for that. We have a few
Welcome.
questions here.
Sure.
I am forwarding them to you so that you can read them as well, but I'm gonna read them out loud for you so that everybody
Okay.
can benefit from them, okay?
Sure.
So from City, I'm not sure, sorry if I pronounce your name wrong, but she is asking to
Mhm.
uh, to please share the key differences between a registration and a trademark.
A registration is basically when you've actually gone through the different stages, for example, filing, examination, publication, and then registration. So it just means that you have the final certificate. It's like a graduation certificate when you go to high school. You get a certificate or university, so it means you've passed all the different stages and you finally got what you need. So an application is just when you initially file it, when you just put your foot forward, you just only put in the papers. So it's just the initial stages. So that's why we call application. And registration is when you've actually already obtained the trademark or the IP. That's the difference.
Thank you.
Okay.
Another question from Itumeling. Is an IP transferable at death? For example, can she include it in her will as inheritance for her kids?
Well, if your IP has value, and again, you can do an IP valuation. There are companies who do that, and if you feel your IP has value, or your company trademark, for example, is of value, we have a registration. Yes, you can will it away. You can even go to a bank, and if it's very valuable, they could give you a loan based on that. So, like Coca-Cola, no problem. They can definitely go use their brand to get loans. So yes, you can do that. So if it becomes valuable enough, yes, you can.
Okay, a question from Tracy. How would it work for an item that you are tweaking slightly and using for a different application?
When you're tweaking it lightly, so I need more clarification. I'm not sure what you mean by tweaking it
Um,
lightly.
Tracy, maybe you can write down and I can continue, more clarification. I can
Yeah.
continue with the next question. Um, I trademark, this is from Helen. I
Hmm.
trademark our snack name and we intend to export. What do
Okay.
you, that would, what would, do we need to file internationally?
Yes, if you're planning to export, yes, like I said, if you are planning to use a distributor or manufacture overseas, I would definitely protect in the countries you're planning to export to, because your people you're dealing with in business could easily file before you, and then you're gonna have trouble trying to get your own brand back, or use it or sell your product for fear of infringement. So yes, I would say yes.
So she should probably
She, you,
try to
you
find out what their laws for that country is,
Correct.
right?
Yes, you need to find out the laws. You need to get in touch with an attorney within that country, or you need to find out the cost. You need to find out the time frame, how long it's going to take, how long does that affect. As long as you filing always blocks third parties, so you don't have to wait for registration for you to be able to block someone from doing something similar or registering something similar. It gets blocked the minute you file. So if you, as long as you're first to file, you block others.
Okay, thank you. This is from me to Melling. If a company owner develops an innovative idea and the employees, as part of their work, develop the idea as a
Hmm.
product for the company, who owns the right to the innovation? Can the
It should
company
be,
owner register it as their own as business property?
yeah, it is. It should be the company. The employer typically would own the IP. Again, you must make sure your contract very clearly spells that out. Your employment contracts. to indicate that the IP that is developed within the company belongs to the company. So that should be in the contract when you hire your employees. It should even be in the contract when you're engaging third parties, so that the ownership issue is not in doubt.
Got it. Another one for Margaret. Say if I have a brand trademark registered in three categories in China and plan to file trademark in other countries, for example, the US, would having an existing registered trademark in one country help further registration in other countries?
No, not necessarily, because we do tend to say that it helps on some level, but because each country has their own examination procedures and practices, they don't really follow what other countries do. It can be of some persuasive value, but usually most of the examiners don't really rely on it. They don't really it doesn't hold weight. We try, but sometimes it doesn't work. So no, it has depends on the different countries and their laws and their rules and practices.
Got it. So we have a clarification from Tracy.
Sure.
To use the toothbrush as an example,
Yes.
how does it work if you take a product design that is currently being used for another purpose,
Yes.
then you market it to use it in a different way? For example, the toothbrush designed to clean teeth, but then I marketed a toothbrush to clean gaps between tiles, for example.
Oh, okay. Well, if the function, it depends on, okay, you want to develop something that works like a toothbrush but does something different. Well, it still cleans, essentially the toothbrush is cleaning. I mean, the whole idea of even if it's used on a different surface, the point is it cleans. If the function of how the product is doing what it does is the same, it doesn't have anything new, then you are going to have difficulty probably protecting it because somebody already has something before you. Again, it depends on the country that they've registered that in. So like the bicycle, a bicycle is a bicycle, but if someone else developed the foldable bicycle, then they can protect that aspect in the different countries separate from all these bicycle owners. It's just, if you can improve on an existing product and you think it's innovative enough, you can go and look into whether it's registrable as a patent. You have to talk to an attorney, of course, on a confidentiality basis, because disclosure must not happen to anyone outside before you file. And then have an assessment of whether this is even patentable in the first place. That's what I would do, and that's what I advise my clients. It depends on what it is that you're trying to protect.
Awesome. And the last question, why is the bicycle not an innovation, but the light bulb is?
The bicycle, I think, was an innovation. I don't know if there's a who probably registered patent, but light bulb, because people used to use candles, right, or kerosene lamps, whereas when the light bulb was developed, where you can just switch on, turn on, and there's lights from electrical outlet. I mean, that's something that was obviously a new innovation. So bicycle can also be an innovation. I think as long as something that is new or an existing product that has been developed to be different. Like previously, our TVs were not flat screen. They were all very huge and bulky TV. Somebody developed the flat screen TV. It does the same thing, but it just became much more sleek and nicer, and now they have the curved TV. So that's all innovation. So the ones who come up with these things will want to protect it and make sure no one copies that. So if you have something like that where you feel you can improve on an existing product, then you can go and determine whether you can protect it as a patent. So it depends. Again, you have to ask the questions. It's good that you're asking the questions. That way you can determine whether you have something valuable that you should protect or not.
Awesome. I think we've met our time perfectly. Do you want to share a screen with your contact information, Kiran? Do you have that?
Yes, I do. Sorry.
I
That's
would
like at the end.
recommend,
Here you
yeah,
go.
I would recommend everybody who has any, further
Question.
consultation. I'm sure that Kiran will be happy to, offer
Yes.
consultation or services for you in
Yes.
your endeavors of setting up the proper processes for your companies.
Yes. I'm
I
happy
would
to do
like
that.
to Yeah, I would like to thank everybody for joining. This webinar has been recorded, so you will receive a follow-up email tomorrow with the access to the recording in case you joined later and you would like to see the webinar from the start. Thank you so much, Kiran. This has been incredibly informative and really easy to understand. So
You're welcome.
congratulations for all that you do, and thank you so much for your time. This was
Thank
amazing.
you.
Thank you,
Thank
everybody.
you, everybody.
Have a great day.
Thank you.